students and inform them about what is an IPR and what are the different opportunities the students have to register their creativity, to patent their work. So we are very happy and fortunate that the IPR Nagpur office has already helped us in conducting such kind of sessions. Last year also we have conducted one or two online sessions, during the COVID. And this year we take this opportunity to conduct an offline sessions on IPR. Now, when we thought about IPR, initially we thought that it is only for those, maybe the faculty members, or it is only for the businessmen, or the big houses, those who wanted to register their work either under trademark, or those science faculties, engineering faculties who wanted to register their patents. We never knew that the students from commerce and management fraternity can also take the benefits of IPR, intellectual property rights. It also helps us to protect our work, our original work. Apart from that, it also inculcates creativity amongst the students. When you know that your work can be patented, your work can be has opportunity to copyright your work. That means nobody else can use your work without your permission. So this is all there, and it also motivates you to use your creativity. I'm not the right person to speak more about IPR, because we have a right person, Nirmala Sinha sir here, who will be guiding you throughout this session, that how students will be benefited with this IPR. What are the different ways you can register your work, you can patent your work. So I hope that all the students present here will take the benefit of this. And I also thank the research team of RGI and Raisoni Business School for conducting such kind of sessions for you people. So once again, I thank you, sir. Thank you, madam, for conducting this session. And I hand over the stage to you. Thank you so much.
24 November 2021, Nagpur, which is the only central government national IPR training institute in India. He has done BE Electronics from Nagpur University in 2001, MTech Materials Engineering from Jawadhpur University, Calcutta in 2004. Sir joined Patent Office in the year 2002 as an examiner of Patents and Designs Group as a Gadget Officer. Promoted to Assistant Controller of Patents and Design in Patent Office, Delhi in Jan 2009. Shifted to Patent Office, Calcutta in May 2011 as a Group Leader of Electrical Group. Promoted to Joint Controller of Patent and Design in RGNIIMP, Nagpur, and joined here on 24th November 2021 as a Head of Office. He has knowledge of foreign languages like French, Spanish, Russian. He has delivered many lectures on IPR in various parts of country. He was deputy twice for a training at European Patent Office, Hague, the Netherlands, and at a World Intellectual Property Organization, Geneva, Switzerland, on examination and CDIP issues respectively. We welcome you, sir. Now I request Dr. to please welcome sir with a sapling and memento as a token of appreciation. Thank you, ma'am.
Initially, we organized a lecture, online lecture with your college, and maybe some of you may be present in that lecture also. So there we gave you a view of IPR. Is it okay? And this and as a part of collaboration with AICTE, and we have come down for this offline session to reach out to all of you to make you aware about the IPR, intellectual property, and its filing processes. So most of you are from BB New Delhi. हम लोगों का जो हेड है, his designation is Controller General of Patents, Designs and Trademarks and Geographical Indications. So all the things come under him. Even copyright also comes under him. So we have a number of offices, sister offices. Patent office is there. We are all from the patent background because I am, as you know, that I am from engineering discipline. So I had a patent background. We joined as examiner of patents and designs. But there are patents office in 4 metros: Calcutta, Delhi, Chennai and Mumbai. In trademarks office is there, registry is there in 5 places in all the 4 metros as well as in Ahmedabad. 4 offices, and I will also show you our Nagpur Institute. This is our Nagpur Institute at beside Hislop College. It is located just nearby the Air India building. And I will give you our website ipindia.gov.in, and from that here you can get to know about the activities which are being carried out in our office, like patents, designs, trademarks, geographical indications, all these offices, how they function. Go to the next slide. This is how our website looks like, and under various tabs we have also a tab of RG and IPM, Rajiv Gandhi National Institute of Intellectual Property Management, where we upload all the latest programs which go on, and all the free programs and the paid programs which are being carried out are being advertised and posted there from time to time. We are also there on social media, in Facebook as well as on Twitter. If you have any queries, you can always post there also. But I will also share with you our email address so that you can post the questions there. We have improved and increased our performance, and we have increased our disposal and grant also. And we have also added, many people have been added to our strength, and we have recruited many people as examiners, and as so that is why there is an improvement. And also we have also changed our practices a bit in order to streamline the whole process of granting procedure, even for patent as well as for trademark. This is the figures of our China. If you see the position of filing of patents and designs for other worldwide, then and if we compare it, then we can see that China has about 1.5 million patent applications which are filed, and India is near to about 50,000 or 60,000, 56,000 patent applications. So it is far below China, but still we are trying to improve. And so if we compare it in 2019 or 2020, previous slide was 2020 figures, then you can see the bulk of filing is from foreign patent applications rather than Indian patent applications. So now we have, as I said, that we have improved our strength, and we have also inducted many new examiners, freshers into our system. So the number of examiners, if you see, has gone up from the previous years, but if we compare it with other patent offices, it is quite low. Means we have only 615 examiners, whereas in other countries like China, there are 13,000 examiners, and because they get more patent applications, they get more, that is why. This is how our patent has filing and grant has increased, and you can see the filing has increased by 5 times, whereas the grant has increased by filing has increased by like 1.5 times, whereas the grant has increased by 5 times. So we are giving some concessions for filing of patents, like we are giving 80% fee concession for startups and SMEs in patents, and also we are giving 80% for fee concession for institutes in filing patent and examination. So request for examination, if you file, you get 80% fee concession for institutes. 80% fee concession for institutes in patent publication fees is also available. Again, 50% fee concession for design fees for startup and SMEs is available. There are for expedited examination, there are particular means there is a fee concession for ladies, so that the lady, if there is a female applicant, then they are eligible to file request for expedited examination. Because with expedited examination, you will get the chance of a faster disposal of patent applications. And then there is a provision of online filing. Video conferencing facility is available for giving hearing, providing hearing, and also SMS alert or notification is available. So, applicant may file a request for expedited examination. We always say, let's go back to the previous slide. We always say that we always, because there is a bad name associated with our office, that they often say that it takes almost 5 to 6 years for a patent to be granted. And that is why many people feel discouraged to apply for a patent, particularly in India. Though the fees is not at the higher side, it is affordable, but due to the time taking thing, they feel discouraged. But now we have introduced a concept of request for expedited examination, which is in Form 18A, along with Form 9, that is request for early publication. So if you file, an applicant files these two forms along with the Form 1, Form 2 and Form 3, if you file Form 9 and Form 18A, then you don't have to wait for 18 months for publication. You will file, your application will be published then and there within 1 month from the filing of Form 9. And Form 18A is for request for expedited examination. It has a fees of ₹8,000, and but the thing is that your application will out of turn, it will be taken up for examination, and within 1 year you are expected to get your patent, if it is, or if other conditions are fulfilled, like novelty, inventive step, and non-patentability or patentability is fulfilled, then you will get this within 1 year you will get a patent. So that is why we introduce these provisions, and also there is facility for 90% refund of examination fees. If someone has lost interest after filing a patent and seeks to withdraw his application, then 90% of fees can be withdrawn, provided examination has not yet started. And if you want to physically file, that provision is also applicable, is also available, but you have to pay 10% higher fees. So as I said that these are the two things which we have recently introduced, Form 9 and Form 18A. Form 18A is applicable for certain conditions are there, means all persons cannot file this request for expedited examination. One of the conditions is that one of the applicants should be female, then only he can apply for this Form 18A, so as for expedite the disposal of patent application. Again, or the applicant should be a startup, or the applicant should be an SME, means small entity, or the applicant has to be a department of the government or a government institute, or like this, and or there has to be a bilateral arrangement between the with some foreign patent office, like Japanese patent office. We have an agreement with them to take up processing of patent application, so they can file request for expedited examination. So recently this news came in Twitter, so I have included this that our domestic filing has surpassed the international foreign filing figures, and that is for the first time it has been achieved in 2022 in these 3 months. If we check the figures of filing for this year, then till March, from January to March, in these 3 months, our domestic filing of patents has surpassed the foreign filing figures. So, if we say that what is the act or the statute which governs these things, then Patents Act 1970 was passed by the Parliament, and it is governing this patents system or patents filing process, and Trademarks Act is for trademarks, and the others act are also there, Designs Act and Semiconductor Integrated Layout Design. So what is this? As you may be knowing that this patent is or design or trademark, these are intellectual properties. So what is exactly an intellectual property? Intellectual property is something which is intangible. So it cannot be exactly measured. We are well aware or acquainted with other forms of property which are movable properties or immovable properties. These are all tangible properties or measurable. These are all measurable. But intellectual property is not exactly measurable. That is why we say it is an intangible property. So intellectual property can be further classified into industrial property and copyrights. Again, industrial property, if we further classify, then it comes to patents, designs, trademarks, and geographical indications. So, why do we give this intellectual property? Why it is in place? The thing is that we want to give shape. Many people want to give shape to creative ideas and expressions of the human mind, and so that they can commercially exploit it. That is why we give this protection to the intellectual property. So it is an asset, just like any other property, movable or immovable property. It is also an asset which can be bought, sold, licensed, and exchanged like any other form of property. So why do we go for intellectual property registration? The reason we go is because we want to avoid duplication of research, so that nobody wastes time behind what is already there, what is already been invented. Again, utilizing the published patent, because published, every time I said that once a patent is filed or a trademark is filed, one has to wait for 18 months before the publication of the examination of the application, and only after publication it will be taken up for after filing of request for examination, it will be taken up for examination. So if one files Form 9, then request for early publication, then publication occurs within 1 month time from the date of filing of Form 9. So this publication occurs like a weekly journal. Patent Office journal is there. Every week it comes out and it is published. It is contains a multitude of information, and all who are going to file patents or even who are attorneys, they are also advised to go through these patent journals so that they get to know about the latest trend of inventions and also the mode of filing of patent application. Again, this what is this intellectual IP? Means intellectual property right. It is a monopoly right which the government gives to you for a limited period of time to commercially exploit your invention. So after this limited period of time expires, this monopoly right ceases to be and it becomes a public property. So you enjoy your monopoly right only for a limited period of time, and then it becomes a public property. And again, it is a server of intellectual indicator of achievements. Means the more you file, the more it will add to your portfolio, because many faculties and many you are also, if you file today a patent, it will add to your portfolio. Once you go and apply for a job, it will certainly elevate your CV or biodata from the rest and make you a separate and person. So you can gain advantage in the professional arena because of this indicator, because of this patent or design or trademark, whichever right you have applied for. Again, as I said, that it is the exclusive right or a monopoly right to make, use, exercise, sell or distribute an invented product or process in India. So it is only limited to India. And right can be shared, your right can be shared, however, monopoly right can be shared, licensed or sold. So these things are, these are the monopoly right which you enjoy for a limited period of time if you have a patent with you or a trademark with you or a design registered in your name. Again, it is, why do we give the monopoly right? It is so as to encourage people to come up with more innovations or more intellectual, so that the society gets the benefit of your inventions. That is why we give this monopoly right, so that you exploit it for a limited period of time, and then your property becomes a public property. You by licensing your monopoly right, you can earn royalty, you can make profits. Again, you can commercially exploit without fear of copying or imitation, because you have already a patent right or a trademark right with you, a certificate you have. That is why the others, you have a weapon in your hand with which you can thwart your competitors, you can challenge them legally, you can initiate legal proceedings against any copying or imitation, any infringement which will occur to your right. We call this infringement. Once any people copying or imitating within your monopoly right, we call this infringement, and you can initiate legal action against him because you are already in possession of the patent or design or trademark certificate. By virtue of trademark, you can improve your market share, you can venture into new markets. You are well aware what is trademark. Trademark is a brand or a logo or a symbol by virtue of which the goods of one trader is distinguished from the goods of other trader. So that is the trademark is an automatic right. Means it comes into being once you launch it into the market. However, if you want the evidentiary value, you have to prove in the court of law, suppose. That is why you go approach the trademark office for registration. But the court does not say that registration of trademark is mandatory, because once it is launched in the market, your right comes into being. But for evidentiary value, you approach the trademark office for TMR, that is trademark registry, for registration of your trademark. Trademark is given for a period of 10 years and it is renewable every 10 years. Creating a corporate identity through a trademark. So you create a corporate identity of your product through trademark. You can negotiate, you can license your trademark, you can franchise your trademark, and you can execute IP-based agreements of your trademark. So if we try to differentiate between the different types of intellectual property, we can see that patent is given for inventions, whereas trademarks are given for words, logos, and slogans and symbols. And then patent is given for technology, and the requirement is novelty, inventive step, industrial applicability, and also your patent should not be non-patentable. But for a trademark, the thing is that newness means it has to be new. It should not be deceptively similar with other trademarks in the market. Suppose ASCO and ESCO, they are almost equal. So your trademark should be distinguishable from other which are already existing in the market. That you have to ensure before launching a product in the market with a trademark. Design is for external appearance of an object. It is the capability of an object to attract more customers by virtue of its aesthetic appearance. That is why we go for registration of design. And again, design is also the same thing. The requirement is novelty or newness. It should be new. Some combination. Suppose two designs are already existing, and you combine both of them and two of them and form another design. So this is not done. Means we can find out. It has to be markedly significant, distinguished, different from what is existing before, or from combination of what is existing before. Only then you can go for registration of a design. Similarly, copyright is given for literary works, for dramatic works, musical works, artistic works. Again, and it is given for the lifetime of the author plus 60 years after his death. And geographical indication, you must be aware that it is given for place names which is associated with, suppose a product belongs to a particular place, like Nagpur orange, or then by virtue of belonging to the place, that particular product comes with certain special properties. That is why the producers of the place wants to GI tag, means geographically indication tag that particular thing. GI register, they approach the GI registry for registration of the geographical indication, so that that particular thing, no other spurious trader or producer can market other products in the name of Nagpur oranges. In order to avoid such unscrupulous persons who are eating away into the profit of genuine traders, they do this GI registration. A single product can have multiple intellectual properties associated with it. Like a laptop or a MacBook can come with some constructional innovations, or like there can be newness with the some patent associated with the processor of the MacBook. Again, the copyright manual which comes, it has the data or information which is there is protected by copyright. Or the logo or the brand is protected by trademark. The design or the external appearance of the MacBook is protected by design. So in this way, before a product is launched in the market, one has to see that there are many types of intellectual property associated with the product. And the particular person, whoever is in charge, has to be assured that he has approached all the offices where all the necessary, has done with all the necessary registrations of these intellectual property rights. So today, if we go for searching of in Google patents, if we go for searching of a ballpoint pen, we can find out that the improved fountain pen or the ballpoint pen was patented in 1939, and it was patented in the US Patent Office. It was patented by some gentleman Bureau, and who made some improvements in the already existing pen, which did not used to work on paper, and he modified the pen tip and used some ink which dried more quickly and did not smudge while writing on paper. So in this way he came up with the invention of the ballpoint pen. And likewise, if we search for these things, some basic things, then we can get many results in Google Patents. And a scientific person or should always know this websites, so that he is aware about this publication, which we have seen in our we have come across. These are done by Mumbai-based startups like Venus Portable Washing Machine. it does not require electric power, and so a scientific person, as I said, a holder of a science degree, whoever, and need to identify the problem and need to identify an idea or an inspiration for doing something new, and then try to address the problem. And one should see that whatever way or method he is suggesting, that is better than already existing methods in the market. So he has to see, and only then he can come up with an invention, and which is patent, for which he can file patent, and he must keep notes of descriptions and drawings of the experiments he has carried out to arrive